Good morning, everyone. Thanks for joining us on your Thursday, last day of the working week, at least for the next month in the UAE. My name's Andrew Fawcett. I'm a senior counsel in Altimini's digital and data team, and we're running this webinar today with my colleagues, Martin Havard, who's the head of our department, and Krishna Jala, who's a senior associate in our team. You'll see that our team is digital and data. We were previously the telecommunications, media and technology team, but clearly data is becoming very much part of our life. I mean, this week has been a week of anniversaries, the 50th anniversary of the UAE, but personally also my anniversary of my 8 years of being in the UAE. And as a lawyer, during that time, there'd always been indications that we were going to get a national federal data protection law. And so here we are. It's been issued. The reason that it's important, obviously, that you're joining in is assuming most of our audience is over 20 or so, that you know how much data and the internet has changed our world. And if you want to participate in the global economy, basically you need to align with the best practices regarding data. And recently, the best practice or the benchmark has, in terms of laws, has been the EU's General Data Protection Regulation, the GDPR. And has sort of set a significant global benchmark. And this new law essentially looks to align the UAE with that benchmark. So I'm a lawyer, and as a good lawyer, I can tell you 15 reasons why there's a change or a flaw in something, which makes me a good lawyer, but not necessarily a good parent when a child, my sons, bring a report card home, and I will go straight to the weakness rather than looking at the overall good report that it is. What I was wanting to start with here is before we dive deeper into this law, is basically, and if anyone who has been involved in the creation of this law is listening in, is you've got a good report card. This law, from what we've seen, looks at achieving that alignment with the GDPR and international benchmarks. But as I say, we're going to dive deeper and look at some of the things where it changed, because part of it could be, you could just say, well, why didn't they just copy the GDPR completely? And there seems to be some simplicity to that, but it's actually really hard to, when you're in a different jurisdiction, different laws, different stakeholders, those kind of things. And we have seen around the world and regionally other attempts to do this, and some of them have got it better than others, and this is in the better than others category. So what we're intending to do today is basically give you a walkthrough in terms of the law. Martin and Krishna and I have read it, so if you haven't necessarily had to do that, we essentially have a black belt, or at least a regional black belt in data protection law, so we can highlight certain things for you. There's a bit of jargon in these laws, so hopefully won't get you too bogged down in that. But we've got a lot to get through and unpack in the next hour, so we'll get along moving with that. In terms of questions, please please feel free to use the chat and Q&A function in terms of that, and we'll monitor those as we go through. But we'll probably what we'll look to do at the end is collect those questions and respond to you via email or otherwise afterwards. We will be able to share the slides, and we will able to share the recording. So without further ado, let's get into the law. So first things first, although the law was actually published only last week, it was issued on the 20th of September. The law becomes effective on 2 January. However, there are to be executive regulations issued, and then companies have a period to comply with that law after the executive regulations has been issued. Now, there's a slight trick and uncertainty in terms of that, and say that the law was actually issued on the 20th of September. The law states that the executive regulations are to be issued within 6 months of that issuance. That's by the 20th of March, and so it's within that period. And then the 6 months runs after that. So it could be that compliance is needed by September next year. It could be somewhat earlier, depending on when the regulations are issued. But we have also had situations with other laws where the executive regulations haven't hit that 6 month period. So there is a transitional period. We can't say exactly right now when you need to be compliant, but it looks like it's going to be fairly short. Next slide, please. So just setting out a few of the definitions from the law. Firstly, just health warding. As you're aware, UAE, the official text of the law is Arabic. We're talking here in terms of an English translation. Some of these terms, not necessarily fully official translations, so some of this translation may not be entirely perfect. But there's a couple of things that I just wanted to draw to your attention here. Because there's a definition of establishment, and a company or a sole proprietorship, but it also includes companies which are wholly or partially owned by the government. Another thing to note is that, and part of this, talking with our team before, is, as I say, we've reviewed the law, gone through it, but when you dip back on, there's things that you see, and I think this is going to be a living experience. So one of these things, and just in preparation now, is it talks about processing, and it's the operations being on personal data by use by electronic means. And checking the Arabic, that's the same. That's a slight difference to the GDPR, for example, because that talks about automated means. And so we may need to look at what that actually means in terms of the compliance with the law. If you're a mum and dad corner dairy and you only do processing of data manually, does that mean the law doesn't apply to you? It's built into the definition, but consent is quite an important thing under the new law, and this is about consent through its nature here being defined as something that is a specific, informed and unambiguous indication of someone's agreement by a statement or a clear affirmative action. And we'll talk a bit more about consent coming along the way. So that's just a bit of an intro to some of the main definitions. Next slide, please. Okay, who does the law apply to? So it's the easy part is someone that applies this, the data subject who resides or have their place of business in the UAE. And it also applies to a controller or processor who is inside the state and it's carrying on processing activities. So basically, it's for businesses that are in the UAE as well. And then C is what we refer to as the extraterritorial impact of the law, is that it also applies to entities that are acting as controllers or processors who are outside of the UAE, but they do processing activities within the UAE. So that can be, for example, overseas entities that use data centers here in the UAE. Even for us, for example, with our Tamimi, we have offices in the DIFC and ADGM, and if we have our other offices onshore processing data on our behalf, that there looks to be some potential for that catching there. Next slide, please. Now, this is an important part of the law as well, and that there's a few carve-outs that we need to understand. Look, it doesn't apply to government data or government authorities who control or process data. Now, that's a factor to be taken into account, but I think it needs to be slightly careful not to overblow that exclusion. Effectively, at least in my view, the genesis and the update of the GDPR was looking at governments regulating the likes of the big data companies, the private companies that were making so much use of data, and there being an imbalance between the private sector and the individuals. So a lot of the GDPR was focused in that regulation by government of private sector. So this is carve out. It is a thing, but if your key takeaway is that it doesn't apply to the government, you may be missing the point of the law. It doesn't apply to personal data processing, stuff you're doing yourself. Now, and getting into the two of the more interesting ones is it doesn't apply to two sectors that already have their own legislation on data processing. And so that's health personal data. The UAE has a federal law dealing with the use of data in the ICT sector that has a lot of controls around data. And then there's also the banking and credit sector, which the UAE Central Bank this year has issued significant regulations regarding consumer protection and consumer data there. And then finally, it's the free zones that have subject to special legislation. That's the Abu Dhabi Global Market, the DIFC, and the Dubai Healthcare City that have specific legislation already. So that's where it doesn't cover. The other significant part of the law is sort of just down the bottom there, is that at the same time of this law coming into force, they also established a new governing entity called the Data Office. And that data office is the regulator for the law, and that's going to have the ability to exempt certain establishments who don't process a large amount of data. So there's some threshold. It looks likely there's going to be some threshold criteria. The Next slide, please. Okay, so this is a little bit more dense. So it's essentially, in terms of data protection laws, you need a start, pass, go basis for processing data. Now, the thing that we've seen, a lot of people have said, this is a consent-based law still. It's drafted that way, but it's effectively, the law says you need consent to process the data subjects information, except in these other situations. Now, the one thing that is interesting, and where the law diverges from the GDPR, is on this basis for processing. In the GDPR, and it is part of the definitions of the law here, there is the concept of special categories of data or sensitive personal data, which has a higher threshold for its processing. But in terms of this basis of processing here under Article 4, it's combined some of that basis into the one thing. Again, linked to the consent aspect of it, but this is one area where the law has some difference from the GDPR. And so basically, you need to come into one of these other basis for processing to process data without consent. Otherwise, you'll need consent to do that still. So important, but actually, what I want you to take away as well is this is actually a good part of the law, and the change here in the UAE is because previously, essentially, we've just had to look at consent. This opens up other grounds on which process can be permitted without consent, but you do need to fall within those. The one other important exemption is that in the GDPR, one of the significant bases for processing is that it's on the basis that it's in the legitimate interest of the controller or a third party, and that has been quite a wide mechanism. It has created a bit of work for lawyers, but it has given a bit more freedom in terms of this legitimate interest basis for processing. As it stands, that reasonably significant basis for processing is missing, but as we've said, that there are executive regulations to be issued. It may be something. It may be something that gets to be looked at later on. But as it stands, that's something that is reasonably significant that's not in the law. Next slide, please. Now, these are the principles behind the law, and essentially these are the aspirational and critical things that you should be dealing with. These are your best practice for data processing. These are essentially consistent with the international benchmarks. Basically, processing has to be fair, transparent, and lawful. It needs to be for a clear, specific purpose, and it shouldn't be processed subsequently for a manner that's incompatible with that purpose. that essentially the data should be, you shouldn't get more data, collect more data than what you need for the purpose, and it should be limited to that purpose. You need to make sure it's accurate and updated. You've got to have appropriate measures to protect regarding the data for its protecting it from unauthorized access. You need to only retain it for as long as you need to. And this is part of the things that it's sort of been expressed by definition under the law, is you can keep data for longer than its purpose, but is at the point that it's anonymized. It's sort of a 101 concept with data protection laws as it applies to personal data. And personal data is about data that that identifies or can identify a person. So if you remove that identification, it ceases to have that character of being personal data and becomes anonymized. Next slide, please. So this is an important change in terms of the law and generally how we've been practicing in the region. As I said before, generally we had been working on the basis of consent, but consent previously had been fairly wide, and that if you'd got someone's click accept to a privacy policy or click accept to a terms and conditions, you could pack into a lot of information into that consent. Going forward, that's going to need to change, and basically consent needs to be clearer and more precise. So if you're relying on consent, and remember, going back, you don't always have to rely on consent now, but if you are relying on consent, you've got to be able to prove that you have got the consent, that the consent that you have has to be clear and unambiguous, and once you've when you're getting it, you also have to indicate that the person has the right to withdraw their consent. Once the consent is withdrawn, it doesn't affect the legality of anything that's been done with consent before that point. Now, while I've said at the outset, there's a transitional period for the law and it's coming into force, this is the kind of thing that you need to be thinking about adjusting right now, in my view, because if you're operating on a basis where you're collecting consents and you're doing that now, and you know this law is coming and these requirements, I think it's really prudent to start making adjustments to do that, because your best ability to get consent, if you need it, is at that time of first interaction. And if you're doing that and you're taking this into account now, it will save you work later on. Next slide, please. And so this is obligations on the controller themselves. So it's necessary for them to take appropriate technical and organisational measures to protect data. This is technical and organisational. So your system, your technology systems, but also your operational measures for protection. There's also, when you are designing the means of processing, you have to look at the appropriate measures, which is kind of what is kind of referred to as protection by design or default. The other thing in the law is if you're appointing a processor, someone who's processing data on your behalf as a controller, the law requires you to get sufficient guarantees that they are going to process the law that meets the processing requirements under law. This is something that I expect to be fleshed out in the executive regulations, because in other jurisdictions, the requirements for the processor need to be set out in a contract, and they're quite prescriptive about what needs to be in that contract. This requirement of guarantees and the indication that there's going to be stipulators and controls in the executive regulations indicates to me that there will be this contractual requirement with some detail involved. And you also have the requirement as controller to interact with the office and provide data to them. Now, so that's a quick track through the first third of the law. I'm now handing over to my colleague Krishna, who'll take you through the middle part.
Thanks, Andrew, for the helpful introduction. Hi, everyone. I'm Krishna Jhala, Senior Associate with Altamimi's Digital and Data team, and I'll take you through the obligations of the processor and data protection officer under the new law. So like Andrew discussed, the obligations of the controller, the processor also has certain obligations that are listed out under the new law, which involves that the processor shall make and carry out processing in accordance with the instructions of the controller and the contracts and agreements concluded between them. So an interesting point to note here is that while the data protection legislations of DIFC and ADGM mandate that there should be an agreement in place between a controller and the processor, the language used in the UAE law is more, it doesn't mandate it, and it actually says that it could be as per the instructions of the controller or the contracts and agreements concluded, and the contracts and agreements concluded. Other than that, the processors shall apply appropriate technical and organizational measures and procedures to protect personal data at the design stage, as well as at the time in terms of the default settings. The processor shall make processing according to the purpose and period, and where the processing exceeds the period, they should make this notification to the controller. The processor shall erase the data after expiry of the processing period or hand it over back to the controller. The processor shall not take any action that would disclose the personal data or the results of processing, except in cases permitted by law. So now the definition of what is permitted by law is not provided, but one would assume this includes arrangements between the controller or the processor, or things where the controller has agreed to by the processor. Further, the processor will protect and secure the processing operations and secure the media and electronic devices used in the processing, as well as the personal data that is stored in those devices. In terms where there involves more than one processor, the law specifically states that there shall be a written agreement between the processors that states the various responsibilities and the obligations to be undertaken by each processor. And in absence of a written agreement, all processors will be jointly held liable for all the obligations and responsibilities under the law. So as you will note, this is quite different than point A of the slide in front of you. So point A says that processing can take place on the instructions of controller and contracts and agreements concluded between the controllers and processors. However, in terms of multiple processors, the law mandates that there should be a written agreement in place which specifies each of theirs responsibilities and obligations. We'll move on to the next slide. The record keeping obligations. For those of you who are familiar with the ADGM and the DIFC data protection regulations, this obligation is similar to the record of processing activities under those laws. And the controller and the processor both have an obligation to maintain a special record of personal data processed, which must include the data of the controller, processor, and data protection officer, the description of categories of personal data held, the data of persons authorized to access such personal data, processing durations, restrictions, and scope. Note that these points C, D, and E may be more extensive than what is found under the DIFC and the ADGM laws. So in that sense, the obligations, the record keeping obligations under the new law seem more extensive than the existing ones under the DIFC and the ADGM laws. And apart from these, It should also include the mechanism for modification, erasure of processing personal data, the purpose of processing data and any movement of data in terms of cross-border transfers, as well as the technical and organizational measures and procedures to be in place and to be implemented both by the controller and the processor. We'll move on to the next slide. Now, when to report a personal data breach. So under the new UAE data protection law, the controller must inform or must let the Office of Data Protection know about the infringement or breach when it prejudices privacy, confidentiality, and security of such data. However, in terms of data subjects, in all cases, the controller must notify the data subjects of the infringement or breach. Vis-a-vis the processor shall immediately, upon becoming aware of an infringement or breach, notify the controller of such breach, and then the controller in turn would need to report to the office if it prejudices the privacy, confidentiality, or security of the data breach. So now, as per the law, it says that this notification by the controller to the Office of Data Protection should be done within a period specified. However, the law at the moment does not specify this period, and we are expecting the executive regulations to provide clarity on the period in which such notification should be made, as well as the conditions and the procedures for making this notification. We'll move on to the next slide. Now, how to report the personal data breach and what all to include. So when reporting a personal data breach, either to the Office of Data Protection, the controllers must include the following information. That is the nature, form, causes, the approximate number and records of infringement or breach, the data of the data protection officer, the potential and expected effects of infringement or breach, procedures and measures taken thereby, and the proposed corrective measures that the controllers or processors intend to implement. And like I said, the time period for such notification has not been specified in the existing law, and we expect that the clarification will be provided by the executive regulations. We'll move on to the next slide. For those of you who are not familiar with the terminology of data protection officer, so data protection officer is essentially a individual within the organization, or it can be a third party individual who was actually responsible to make sure that the data processing activities of the organization are in compliance with the applicable law. So now, much like the other international data protection legislations, the UAE data protection legislation has also included this obligation to appoint a data protection officer in certain circumstances. And these circumstances include where the processing would cause a high level risk to the confidentiality and privacy of the personal data of the data subject as a result of adopting technologies that are new or associated with the amount of data. Another condition is if the processing will involve a systematic and comprehensive assessment of sensitive personal data, which includes profiling or automated processing. The third condition is if the processing will be made on a large amount of sensitive personal data. So the ones of you who are familiar with the data protection legislations of ADG, MDIFC, you will note that the phrases used for these thresholds are quite similar to the high risk processing activities defined under those laws. The UAE federal law does not categorize these thresholds as high risk processing activities, but essentially it would mean the same. Now the DPO can be employed within the organization or can be a person authorized by a controller or processor, and such an individual can be based inside or outside the UAE. It's interesting to note that while the UAE data protection law does not specifically state that a group DPO should work, but one would assume that the terminology of inside or outside UAE would essentially mean that. We would move on to the next slide. Okay, the responsibilities of a data protection officer. So the responsibilities will include verifying the quality and validity of the procedures adopted by both the controller and the processor, receiving requests and complaints related to personal data in accordance with the provisions of the degree of the existing law, providing technical advice related to the procedures of periodic valuations and examinations of personal data protection systems, and acting as a liaison between controller and the processor. The DPO shall at all times maintain confidentiality of the information and the data it receives. We'll move on to the next slide. So what are the obligations of the controller and processor vis-a-vis the DPO? So the DPO, while appointing a DPO, the controller and the processor should ensure that the DPO is appointed in a timely manner and ensure that the DPO is provided with all necessary resources and support to perform the duties. This is an interest point. C is an interesting one, which says that the DPO shall not be terminated of his services or be imposed of disciplinary penalties for performing their duties in accordance with the provisions of the law. So this is something that the controller and the processors need to keep in mind. The controllers and processors also should ensure that the DPO is not assigned to duties that that lead to conflict of interest with his existing duties within the organization. And the DPO should have an open channel of communications with the data subjects directly, and they can complain to him about their data, the manner in which the data is being processed, or if they feel that the data has been breached in any way. So there should be open communication between the DPO and the data subjects, which should obviously be kept confidential. Like I said, I've run you through the obligations of the processor and the data protection officer. I will now hand over the presentation to Martin, who will take you through the remainder of the law.
Martin, I'm just going to quickly jump in from some of the questions on coming up from my part, just to be clear to people. As I mentioned that the law doesn't apply to certain entities, being banks and health and certain free zone entities. That only doesn't apply where there is legislation in place that already covers data protection. And so that's in limited scenarios. So as I said, if you're in a free zone, it's not every free zone. It's the DIC, the ADGM, and to the extent it's still applicable, the Dubai Healthcare City. The banking sector has, the central bank has issued specific regulations around consumer data protection, and in the health sector, there's the federal law on the ICT that's the use of ICT in health that has lots of data protection provisions in it, and there are also health authority regulations on it. So it's not you're in that sector, it doesn't apply. It's or you're in a free zone. It's where there's other legislation. So just clarifying that point. Sorry, Martin, over to you again.
No, thanks for that, Andrew. Because yeah, watching the chat, we've had a lot of discussion on that, and thanks to everybody for posting on that. I mean, it's an interesting one, in particularly in the financial services sector, because over the last 2 years, with digital transformation accelerating, we've seen banks rolling out a lot of non-regulated entities to do lots of different things that they certainly weren't doing a few years ago. So it's going to be interesting, and a lot of those entities are very data heavy. So it's going to be very interesting to see how the new law applies. But anyway, we are perfectly on time. Andrew, Krishna, thanks so much for the heavy lifting so far. So for the next 20 minutes, I'm going to walk you through the final parts of the law. We're going to start with data subjects' rights, and this is new to the UAE. It's certainly not new to the GDPR. It's certainly not new to the DIFC and ADGM data protection legislation, but it's going to be very new to a lot of UAE companies. And this comes with a lot of new obligations, and it's important that UAE companies start getting comfortable with these data subject rights, because particularly what it's going to require is companies making sure that they have processes and procedures in place to make sure that they can effectively respond to these data subject rights. When a data subject comes to you and says, look, I want to exercise one of these rights, you're going to need to make sure that you're going to be able to manage that effectively. And we've listed up the data subject rights there. We're going to walk through each of them. A number of them we're going to spend a little bit more time on. So let's jump into it. Data subject's right to obtain information from the controller. So this, a little different to kind of this is certainly not something that's new to us, looking at other data protection legislation. It's interesting because in a lot of other data protection legislation, there's a requirement that the controller puts this information out there in the form of notices and policies and things. This is a little different in terms of this is the data subject's ability to request this information from the controller. And there's a list there of the things that the data subject is going to be able to ask for. And we've highlighted a couple of those, B, D, and G, because when you look into Article 13, and we haven't got it listed here on the slides, but Article 13.2 says that in all cases, the controller must, before starting the processing, provide the data subjects with the information stipulated in paragraphs B, D, and G. So there is going to be a requirement on controllers to get this information out to data subjects ahead of time. And that is certainly our interpretation of that, is that there's going to be a proactive requirement on controllers to get notices out there, rather than what is really with Article 13, more of a reactive response from controllers to data subject requests. Now, that's going to lead to a question for controllers in terms of how they manage that. Are they going to go the route of, say, a GDPR, DIFC, ADGM, where they basically develop very detailed notices, really covering everything they're doing from a data processing position, and then they get that information out there to the data subjects? You know, as I say, that can be in the form of notices, policies, various other things, or is it going to be a lot leaner and just stick to the requirements? So that's going to be an interesting one. The Article 13 as well makes clear that there are limits to what those requests can do. So equally, if those requests are for information that's not listed in Article 13, then that's something that a controller can push back on. If there are excessively repetitive requests from data subjects, then equally that's something that controllers can push back on. And then there's various other limbs in Article 13.3 which allow controllers, really from a controller position, what you're going to need to do is to assess each request for information. Some you can probably manage very easily, and the notices and things like that will allow you to do that. You have an opportunity to assess each request for information, to think about whether it's something that you have to respond to under the law. And equally, there's the requirement under the law that, of course, if you do respond and you do provide data subjects with that information, that, of course, you're not affecting the privacy and confidentiality of other third parties. So you know that you'll need to redact things to make sure that you're not providing third-party data to the data subjects. So we're going to jump on to Article 15. We're going to come back to 14, but 15 is more interesting because this is basically the data subject's right to rectify or secure the erasure of personal data. And once again, this is going to come with a new administrative burden for controllers and for UAE companies who have not had to deal with this before. You're going to have processes and procedures in place in your organization to be able to correct personal data that's inaccurate, or to complete personal data that's incomplete, or if the data subject requests it, to erase that personal data. And there's various things set out in the law in terms of when a data subject can come and ask for that correction, for that completion, or for the erasure. And you know, you'll note things like where the data subject withdraws his or her consent when the process on which the processing is based, or feels that there is no legitimate reason for the controller to continue the processing. And D, actually, if you look at that, is pretty broad, because it actually talks about the violation of provisions of the decree and legislation. So once again, data controllers are really going to have to do an assessment of these, and it's putting those mechanisms in place that when you get this request, that you can manage it. Now, of course, as we've set out, there are certain exceptions, and that's pretty standard in data subject rights. There's going to be certain limitations to what a data subject is able to do, and we've listed those there, and you know, they're relatively common sense in terms of where there are investigation procedures going on, for example, involving the controller, where a request to correct or complete or erase data conflicts with other legislation to which the controller is subject. And this is an interesting one as well, because this is one where the controller is really going to need to be on top of what data it needs to retain under other legislation, not simply data protection legislation, but what data do they have to hold? Because they're going to have to justify that back to the data subject. They're not simply going to be able to say, I'm sorry, we have to hold this for legal reasons. You're going to have to be able to demonstrate why. And then Article 15, and we haven't put it up on the slide, but Article 15 also talks about that there may be other exceptions that are included in the executive regulations. And as Andrew started at kind of talking to at the start of the session, you know, there's a lot in those executive regulations that we're going to need to see. So we're going to jump on to 16, which is also the ability to for the data subject to limit what the controller does with their data. And that comes in two ways. That's either restricting the controller from processing that data under certain circumstances, or alternatively to asking the controller to retain that personal data, where, for example, the controller may want to delete or otherwise destroy that data. So once again, there's UAE companies who are going to be controllers of personal data are really going to look at how they manage these kind of requests. And once again, there are exceptions to that, and that's at the bottom of the slide. And an interesting one is this processing is limited to storing personal data. You know, that's pretty broad. We've been talking about that internally, just trying to get our heads around really what the implication of that would be. Now, as you can see from the exceptions to this right to restrict processing, the controller can do it without the data subject's consent, but they have to notify. So once again, it goes back to that information delivery requirement. You need to be telling data subjects what you're going to do. And for that reason, if you go into policies and notices under other data protection laws, there's a lot in there on data subject rights. There's a lot of information that's included talking through what the controllers are doing, what they're able to do, what they're not able to do in relation to data subject rights. Right, so we're going to go on to Article 18, which is specifically looking at automated processing. And certainly for us as a digital and data team, where we've been working on a lot of projects, particularly over the last couple of years, in a lot of different industry sectors, where we're seeing a lot of automated processing coming in. And this is something that UAE companies have not had to deal with to date. Companies under other data protection laws have had to deal with managing data subject rights around automated processing, and those automated processing where they have legal consequences or seriously affect the data subject. So decisions are being made about the data subject through automated processes. And of course, you know, what data protection laws do is really make sure that there's transparency involved, that data subjects know how this automated processing works, and that they can also engage with that process. They can ask for human resources to be brought in to review automated processing decisions, that the controller is using appropriate procedures and measures to protect privacy and confidentiality in relation to that. The interesting thing is the second bullet, where the data subject may not object to decisions issued with respect to automated processing, and we've included, and that's basically where they've been told about that automated processing. There's a couple of other limbs or they've given consent. So for a lot of UAE companies that are doing automated processing, it's going to be really important that you look at what you're doing. And then you're either going out and getting consents, and we've talked about what consents need to look like, or you're getting it into the terms of your contracts with the data subjects, your terms and conditions, really setting out what you're doing, getting it into your notices as well. So we're just going to flip back very quickly. As I say, we'll be circulating the slides, so you'll have this detail. So Article 17 and Article 14. Article 17, but let's start with Article 14 first. We'll do it in numerical order. This is very much the right to data portability. It's the ability for a data subject to come in and ask for their data to be moved from one controller to another. And we see this in different industry sectors, telecoms, for example. And once again, it's really going to require controllers to have processes and procedures in place to be able to do this. Now, there is a caveat that it's got to be technically feasible. But often when we've seen this interpreted, it's a broad interpretation. It's difficult for controllers to argue, well, look, I don't know really where the data is, so I can't provide it to the data subject to move it over to a third party. That's often very difficult to argue by a controller. So they have to have these mechanisms in place. The right to stop processing. So there's a number of limbs to this. The really interesting one, and they've already seen some stuff coming up on the chat on this, is really around direct marketing and how this works with the current requirements in the spam regulations under the TDRA. And this is one that's going to need some review. I mean, the other thing around the right to stop processing is where processing is in violation of Article 5. These are the data protection principles. These are really broad. So that's actually quite a broad data subject right. Okay, so got about 7-8 minutes to go. We may well run over a little bit, so apologies about that. We're going to move through because we've got a couple of really important slides to cover, particularly around data transfers. Personal data security is Article 20. We've highlighted the fact that this is both a controller and a processor obligation. So both controllers and processors are going to have to be looking under the law, not simply from, say, for example, from a processor's point of view, a contractual obligation that's applied by the controller. But under the law, both controllers and processors are going to be obliged to put appropriate technical and organizational measures in place. There's some examples in the law in terms of what that's going to look like. It's pretty broad. You know, we're certainly going to, there's different standards we can look into when we start trying to understand what best international standards and practices are, both UAE standards and more broadly, to really understand what you need to put in place. But the key thing is it's a risk-based approach. And the Article 20 makes that clear. Depending, you've got to do that assessment, depending on the type of personal data that's being processed. How much of it? Is it sensitive personal data? All of this stuff needs to go into that analysis because, of course, IT security costs money. It takes time to implement and maintain and update. And controllers and processors are going to be looking at what they have in place at the moment. They're going to be trying to determine whether that meets the Article 20 requirements. And they're going to be trying to work through, okay, if it doesn't, what do we need to put in place? They're going to need to do, really, they need to do that data mapping exercise. What Krishna was talking about in relation to the recording what you're doing from a data protection position. Really, you need that data mapping in place to really understand what data do you have and then what protections you need to put in place. So, not going to talk too much about Article 21. For anyone who's kind of worked with GDPR, DIFC, ADGM laws, we see this as a data protection impact assessment, really around the use of modern technologies and where they're involved in assessments of around automated processing and also around large amounts of sensitive personal data. So once again, UAE companies who are controllers of personal data are going to need to be looking at what am I doing from a data processing point of view? What technologies am I using? Artificial intelligence, blockchain, lots of different ones spring to mind. What am I doing? And do I need to do a data protection impact assessment? And the Article 21 talks to really what that assessment needs to cover. And this will be as UAE companies start planning out their compliance framework and thinking, what am I prioritizing in relation to kind of being compliant with the new law? The DPIAs, data protection impact assessments, are going to be one they're going to need to factor in. And we've been doing a lot of these under other laws, a lot around workplace technologies that are being brought in, particularly COVID related, and a lot of that's attracting DPIAs. So let's get into this one, because this is really important. This is data transfer, and we're already getting a lot of queries from clients around this, particularly in relation to the use of certain technologies like cloud. And this is really looking at, okay, how, under what circumstances can we transfer personal data? Because previously under the kind of old UAE laws, and there was never a dedicated data protection law, but there was lots of data protection provisions in lots of different laws. It was quite a simple process in terms of transferring, making sure you had the consent to do it. We're now moving towards more kind of best practice in relation to data protection, in relation to transferring personal data. And that's split between transferring to jurisdictions that have an adequate level of protection and ones that don't. Article 22 covers adequate, Article 23 covers non-adequate. Article 22 will be, there will be countries, and our expectation will be that the office will issue a list. Now, we're already seeing kind of commentary in terms of, is the office going to be doing this on a case-by-case basis? Our expectation would be the executive regulations will have a list of those countries that will fall within the adequate bucket, that have special legislation in place for the protection of personal data. You can look at the DIFC laws and the ADGM and see their lists, and kind of that will give you a guide, perhaps in terms of what you may well see from the UAE. But we'll be interested to see which countries are covered on those lists and which aren't. And that's the simple bit. So once you have the list, and this will be updated over time by the office, this one's going to be the trickier one, where you're doing data transfers to countries that aren't identified. They don't have an adequate level of protection in place. They don't have a data protection law. So how are we going to manage it? Well, the good thing is Article 23 has a number of different ways in which data will be able to be transferred. And a lot of these are very familiar. Well, actually Article 23(1)(a), I should say, talks about implementing provisions, measures, controls, and requirements between the controllers and processors to sending that information from inside the UAE, outside the UAE. And we would kind of see that along the lines of what we know as standard contract clauses, model clauses, contracts that are put in place that set out specific requirements around those data transfers. Consent is going to be one means by which a data subject is going to be able to transfer personal data outside the UAE. There's some caveats around that, but once again, going back to the requirement that consent is clear, unambiguous, really making sure that you can track that data subject consent to that transfer, that data subject knows where that personal data is going. Transfers necessary to execute a contract between the data controller and data subject, or between the controller and third party to achieve the data subject's interest. That needs some looking at in terms of how that will work. So the key takeaway from that is there's clearly going to be means in which UAE companies are going to continue to be able to transfer data out of the UAE. Of course, a lot of UAE companies are parts of global networks, regional networks, using shared services, moving data all over the place. They need to be able to do those kind of cross-border transfers. So just to end, last couple of minutes, appreciate everybody's time. Just looking at Article 24, filing complaints, and of course the big topic around penalties and violations. So there's going to be a mechanism with the data office in terms of the ability to file complaints. It'd be interesting to see how that's pulled together the office will be able to impose administrative penalties. This has certainly been, of course, one that's had a lot of discussion about what those penalties are going to look like. We don't have any information on that yet. We would expect that in the executive regulations or in other releases from government on that. So there's a bit of a wait and see in terms of what penalties are going to look like. But certain and equally, as the data office gets set up, and we'll talk very quickly about data office beforehand, it's going to play a very key role in terms of how things are managed. Article 30 is quite interesting because this talks about any provision contrary to or in conflict with the provisions of this decree law shall be repealed. That's a very broad article. We're interested to see how that's going to be interpreted. We've got our views on that. We're kind of still processing really what that's going to mean in practice. So just very quickly on the Data Protection Office, and I'll also, once I'm done, I'll also kind of ask Andrew and Krishna if they've got any last words. I'm actually going to go back to Article 19, because that's actually a very important one, just to flag where there's a requirement from the controller that they provide appropriate and clear ways and mechanisms to enable the data subject to communicate with the controller. And this is a really important thing that UAE companies need to be aware of. They're going to need to set up mechanisms by which data subjects can get in contact. Sounds like more than one. Depending on your data protection law, there are different ways of doing it in terms of number of ways to communicate: emails, telephone, mail, all the normal channels. But it's something that controllers are going to need to put in place to enable data subjects to effectively be able to communicate with them. So onto the Data Protection Office. So as we've said, this is under Federal Law number 44 of 2021, came out at the same time as the Data Protection Law. And there's a lot of interest here around what the Data Office is going to look like, who's going to staff it, what it's, you know, there's a lot of information in the new law in terms of what its mandate is, and it's, you know, it's going to be really interesting to see how it's going to lead on a lot of the requirements in the law, preparing legislation, standards, policies, and guidance in relation to data protection, the awareness raising. We've seen it from the regulatory authorities in the IFC and ADGM, for example, how they've really, you know, their thought leadership and awareness raising in terms of the requirements of the law. As we've talked about before, the office is going to be involved in imposing penalties for the contravention of the law. They're going to be the body that's monitoring the application of the law, our controllers and processors fulfilling the requirements of the law. They're going to be doing those investigations. They're going to be managing the complaints and the appeals processes. So a really, really important part of the law. We've seen this across the Middle East, whether we're in Egypt, Bahrain, Saudi. You know, the key is really around that regulatory authority when it's set up. It's certainly, the law talks about the fact that for the first couple of years, it's going to be supported by the TDRA. So we want to see this in place, and we're looking forward to seeing what the data office is going to be. Is it going to be very proactive? How it's really going to operationalize the new law. So that's everything from us. We're about 4 minutes over. As we flagged at the start, what we're going to do is come back on the Q&A and the chat. And there's been a lot of questions put in the chat. Now we're capturing all of that. And what we're going to, rather than kind of address some of these now, in the interest of time, what we're going to do is to respond to you all individually. In this new data protection world, we have all your details. And so we will be reaching out to you over the next few days. Give us a little bit of time to kind of process that, but we're looking forward to engaging. Thank you very much for the Q&A and the questions that have been put in the chat. We will come back to you on those, and we're looking forward to starting a conversation with you about those points. So that's very much been with us. As Andrew set out at the start, this was very much meant to be a first walkthrough of the new law. And we know that, you know, from talking to our clients already, people are getting their heads around really what this means. How do we operationalize it? What do we prioritize? You know, where should we be focusing? and really starting to think a lot more about, okay, well, what personal data do I have? Who are the data subjects? Where is that personal data stored? Where do I send that personal data to? Who do I send that personal data to? Who of those third-party suppliers do I have? Do I mostly have employee data? Is it client data? Is it third-party supplier data? Do I, do I have large amounts of sensitive personal data? What technologies am I applying to that personal data? And that's always a tricky one, because that's often something that's siloed within your IT departments, or perhaps HR or marketing, and you don't have visibility of that. So that's really going to be an important investigation. But that's everything from me. Just going to use this opportunity to thank Andrew and Krishna for their support on this presentation. I hope it was of use. We look forward to kind of getting your feedback on it, and as I say, to engaging with you in terms of your questions. So with that, we will draw a line under it. We'll let you get back to your days. It's the end of the week, and I'm sure you've got a lot to do. We wish you a very happy weekend. Enjoy the glorious weather we're having at the moment. And as I say, thank you again for attending.
Thanks, everyone.
Thanks, everyone.